you wake up tomorrow or the next day and you decide you've changed your mind and you want to resolve this case, both cases, by way of a jury trial, that's not going to happen. If you want to have a trial, the trial starts tomorrow. If you want to accept the deal, you can accept the deal today. But there's not going to be any buyer's remorse, in other words.
A shocking update in the double murder case against rapper YNW Melly. Not only was his murder trial pushed to 2027, but his alleged accomplice struck a deal with prosecutors.
The maximum penalty is 15 years in Florida State. So, sir, again, before the agreement you made with the state, before the deal you made with the state, your maximum exposure here was life in Florida State Prison, followed by 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 75 years in Florida State Prison.
We're breaking down what strings come attached to the deal and what it could mean for Melly's future retrial.
Mr. Henry, I'm not quite sure how your lawyers managed to do this, but I wish you good luck, sir.
Thanks for joining us on Law and Crime. I'm Elizabeth Millner. Cortlen Henry was accused of helping YNW Melly cover up the murders of their friends. However, in a deal with the state, Cortlen, or YNW Bortlen, had his murder charges dropped, meaning no more life in prison. But will he testify against Melly, who prosecutors allege pulled the trigger?
He's standing next to me in that area, and then at one point I just have him sit down because he's just so, all over the place.
Did he ultimately identify himself to you?
Yes, ma'am.
And what was the name that he provided?
I believe it's Cortlen Henry.
That was Officer Jessica Amingor with the Miramar Police Department, describing what she saw the night Cortlen Henry rushed Anthony Williams and Christopher Thomas Jr. to a local hospital after they had been shot.
And you mentioned that there were some individuals inside. How many people occupied the vehicle at the time when you saw it?
One gentleman in the front passenger seat and one in the rear right passenger seat.
And when you approached the vehicle, was it apparent their condition?
Yes, they weren't moving.
Okay. How so were you able to, determine whether or not they were injured?
So immediately looking on the vehicle and, just the fact that there was multiple bullet holes in the side, they weren't moving. If somebody was able for me to help them, they'd be in obvious pain, screaming, moaning, and there's nothing.
Did you attempt to render aid?
Yes. So I immediately, after waiting in for assistance and letting the security guard at the desk, hey, I need doctors and nurses and everything to come out to help me, put on gloves and reached inside the front passenger seat and checked the pulse of the gentleman, the right wrist. I didn't find anything.
And did he tell you where the circumstances surrounding how he ended up at the hospital?
So he advised he just left the studio with his friends in Fort Lauderdale, and that he wasn't familiar with the area, but he had just gotten off a highway because they're staying at a home somewhere near the hospital. After he got off the highway, he was stopped at a light, and then the car, he couldn't tell me exactly what kind of car it was, just started shooting at his vehicle. So he multiple times reenacting a story, he's going like this, because he's saying that he had to duck down in the driver's seat as he was driving to avoid being hit.
And again, along those lines, you said that it was immediately apparent as to the other victims inside the vehicle. Were you able to observe any injuries to Cortlen Henry?
No.
Were you able to observe any blood?
No. I actually told him several times that he was lucky because for that many bullet holes, I was surprised he didn't get hit.
So that officer testified during YNW Melly's first trial, and we all know how that turned out.
We all received a juror inquiry form. It indicates that after further discussions, reviewing the evidence and speaking freely amongst the jurors, we are still unable to reach a unanimous decision. So at this time, what I'm going to do is just declare a mistrial because it's mistrial.
Now, years after that mistrial was declared, the very alleged accomplice accused of helping Melly cover up a double murder struck a deal with prosecutors. Now, before we get into that, let's start with how we got here. Now, back in October of 2018, some members of the YNW Collective were at a late-night studio session recording music. That included Jamel Dimmons, a.k.a. YNW Melly, Anthony Williams, a.k.a. YNW Sakchaser, Christopher Thomas Jr., a.k.a. YNW Juvy, and Cortlen Henry, a.k.a. YNW Bortlen. Investigators allege that during that ride home, Melly shot and killed his childhood friends Sakchaser and Juvy, and Cortlen Henry, a.k.a. YNW Bortlen, helped cover it up. Melly and Bortlen denied that, and Melly's defense team during his first trial even denied that he was in the car that night, even when the bullets flew. Despite surveillance videos showing them enter the car, Melly's defense claims at some point during the ride home he hopped out, and that Juvy, Sakchaser, and Bortlen were victims of a drive-by, which is why during Officer Amingor's testimony, you don't hear her talk about Melly much. Now stay with me. Melly and Bortlen were both charged with 2 counts of first-degree murder plus more charges. And as I've mentioned before, Melly went to trial and that ended in a mistrial. Now, Bortlen was supposed to go on trial this week, but that didn't happen because in a shocking move, he accepted a plea deal from prosecutors. In exchange, they'll drop the double murder charges against him.
So I had set this afternoon for the deadline as to whether or not Mr. Henry wanted to accept the state's offer or not. We're set to go with jury selection tomorrow morning. So Mr. Haddad or Mr. Nascimento, we're going forward to change your plea this afternoon? And state, is it the same terms that you discussed previously? Is there anything different?
No, Your Honor, that has changed. It's correctly reflected on the plea forms.
So the preforms to me look like on the 19th case as to the 2 counts of accessory after the fact, as well as to all 4 counts in the 23 case. These are going to be adjudications, 10 years Florida State Prison, followed by, that's a 6 years probation?
That's correct, Your Honor.
6 years probation. All counts will run concurrently, all sentences run concurrently with one another. And it looks like there's no restitution in the 23 case. In the 19 case, I'm reserving restitution and ordering it payable. That's going to be to Terry Bagley as well as Ashley Phillips.
Yes, Your Honor.
So we now have to
We've spoken to them and they don't anticipate there being any restitution, just because it's caution.
Okay. Okay, well, I'll give you 120 days to tell me the amount. If there's
Yes,
no
Your Honor.
amount, you won't give me restitution.
They are present as well, too, so our victim advocate has informed them that if
Okay.
there's any restitution, they would let us know.
Okay.
As of today, they said there is none.
All right, and state, is that the complete term? That's it?
He's also going to be giving it to proffer, Your Honor, at a later time.
So, well, is that part of the negotiated
Your Honor.
resolution?
It is.
So that's a lot of legal jargon, right? But let's break it down. Cortlen Henry accepted a deal to plead no contest to being an accessory after the fact, meaning he really didn't plead guilty, but the judge adjudicated him or declared him guilty on that accessory charge. So Cortlen will still have to be serving a prison sentence, but he was sentenced to 10 years followed by 6 years of probation with credit for time served, which honestly, compared to a life sentence, maybe that helped him come to that decision. But let's take a look at how that conversation went.
Mr. Henry, I'm going to put you under oath, and I'm going to ask you some questions. If I ask you something you don't understand, please let me know. I'll try to ask you a better question, okay? As loud as you can so the court reporter can get down all the answers, okay? Raise your right hand for me, please. You swear to tell the truth, the whole truth, nothing but the truth? You can put your hand down. Please state your full name. How old are you? How far did you go in school? Do you read and understand the English language? Are you presently under the influence of any drugs, medication, or alcohol? Have you ever been treated for a mental illness? Are they giving you any medication in the jail right now? How are you feeling this afternoon? Your head is clear? You understand what's going on this afternoon? You understand you're resolving 2 pending felony cases this afternoon? Mr. Haddad or Mr. Nascimento, have you seen or heard Mr. Henry say or do anything which would call into question in your mind whether he understands what's going on?
Nothing at all. No, Your Honor.
All right, so Mr. Henry, it's 2 cases, sir. I'm going to go one at a time. In case number 19-1871 CF10A, this is before the agreement you made with the state, before the deal you made with the state. You were charged as follows. Counts 1 and 2 is murder in the first degree with a firearm. Those are capital offenses. The maximum and mandatory penalty is life in Florida State Prison. Counts 3 and 4 are accessory after the fact to murder in the first degree. Those are each first degree felonies. The maximum penalty is 30 years in Florida State Prison. In case number 23-10643 CF10A, you're charged at count 1, tampering with a witness in a capital felony. That is punishable by life in Florida State Prison. Count 2, directing the activities of a criminal gang. That's a first degree felony. Again, punishable up to life in Florida State Prison. Count 5 is conspiracy to commit tampering. Again, as it relates to a first degree murder charge, that is punishable by a maximum penalty of life in Florida State Prison. And count 7, unlawful use of a 2-way communication device as charged. That's a second degree felony. The maximum penalty is 15 years in Florida State Prison. So, sir, again, before the agreement you made with the state, before the deal you made with the state, your maximum exposure here was life in Florida State Prison, followed by 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 75 years in Florida State Prison. Sir, do you understand all the pending charges and the maximum possible penalties involved? And it's my understanding that you want to resolve both cases today. Is that correct? And that resolution is an agreement you've reached with the state, the terms of which are as follows. Number one, in the 19 case, you're going to plead no contest to both counts of accessory after the fact. In the 23 case, you're going to plead no contest to all 4 counts as charged. In exchange for that, the state is going to null pros, that is, drop the 2 first-degree murder counts. All right, I'm going to adjudicate you guilty. Yes, sir. What's happening with that?
That would be no problem.
So he's only going to plead to the tampering with a witness in a capital felony, conspiracy to commit tampering, and unlawful use of a two-way communication device?
Just the tampering and the unlawful use.
Just count 1 and count 7.
Correct.
State, you're going to null pros count 2 and count 5,
Correct, Your Honor.
as it relates only to Mr. Henry.
Correct.
Okay. So, Mr. Henry, what it's going to be is 2 counts of accessory after the fact, tampering with a witness in a capital felony, and unlawful use of a two-way communication device. In exchange for that, I'm going to adjudicate you guilty on the 2 accessory counts as well as the tampering count. I'm going to sentence you to 10 years in Florida State Prison. That will be followed by 6 years of reporting probation. In the unlawful use of a two-way communication device, that's a second-degree felony. The maximum exposure.
It's a third degree, Your Honor.
It's the second as charged, I believe. It's a third, except as it relates to a capital case. But I'm happy to
Our
look it up.
team has it as a third, that's what we discussed, so.
Well, what did you want the negotiated sentence to be for that?
That was just going to be the maximum time served.
5 years? Is that what you want me to do?
Correct, Your Honor.
Okay. All right, so, sir, as to that count, it's going to be an adjudication of 5 years in Florida State Prison. So the 2 accessory counts as well as the tampering count, those come with 6 years of reporting probation after the Department of Corrections sentence. I'll give you credit for all the time that you've served in both cases. All of those counts will run concurrently. All those sentences will run concurrently. All counts in all cases, that is at the same time with each other. I'm going to have to impose mandatory court costs. I'm going to order restitution payable to Terry Bagley and payable to Ashley Phillips and reservists to the amount. I'm going to give the state 120 days to tell me the amount of that restitution. If they fail to do so within 120 days, there will be no restitution. If they come back with an amount and the attorneys agree on the amount, I will impose that as another condition of your sentence to pay back that restitution. If they come back with an amount and the attorneys do not agree on the amount, I will conduct a restitution hearing. Sir, lastly, and I want to make it very clear on the record, and it's unrelated to this negotiated change of plea, I guess at some point after the fact, the state wants to take a proffer from you or have a discussion with you, ask you some questions about whatever that may be. What I want you to understand, sir, is I guess that's part of this negotiated resolution, but your answers to any of those questions, whatever they might be, have no bearing on me and have no bearing on this negotiated resolution. In other words, the deal you've negotiated is the deal you've negotiated, and that's the ballgame. Do you understand all that, sir? Have you had enough time to talk to your lawyers about all that? They've answered all your questions? You're sure that that's what you want to do? Because I want to emphasize, Mr. Henry, and I'm going to do this again at the end of my plea colloquy, whether you resolve the case by way of a negotiated plea or an open plea to me, or you resolve the case by way of a trial, it doesn't matter to me at all. But due to the resources that have been devoted to this case, I have 250 jurors summoned for jury duty starting tomorrow. So I want to be very thorough with you here this afternoon, because if you wake up tomorrow or the next day and you decide you've changed your mind and you want to resolve this case, both cases, by way of a jury trial, that's not going to happen. All right? If you want to have a trial, the trial starts tomorrow. If you want to accept the deal, you can accept the deal today. But there's not going to be any buyer's remorse, in other words, because I've given you plenty of time to think about this, talk to your lawyers about it, talk to your family about it. I talked to you about it last week. Kind of looks like your lawyers probably did something or other to get a better disposition for you as of this afternoon, but this is it today. So understanding all that, you've had enough time to talk to your lawyers about all that, that's what you want to do? So, sir, has anyone forced you, threatened you, or coerced you into entering these pleas? If I accept your pleas, there will not be a trial in either one of these cases. Do you understand that? If I accept these pleas, there's a whole bunch of constitutional rights you are giving up. I want to make sure you understand all of those rights. You have the right to maintain your plea of not guilty and have a trial in each case. You have the right to present defenses, to file motions and other pleadings in support of your defense. You have the right to remain silent. You have the right to have the state prove you guilty beyond a reasonable doubt. You have the right to confront and cross-examine the witnesses against you. You have the right to appeal any decisions that I may have made up to this point or any rulings I might make in a future trial. But understanding by entering this negotiated resolution today, you are giving up all of those rights. The matter is going to be resolved today, right now, this afternoon. Is that what you want to do? Are you satisfied with your lawyers? Have you had enough time to speak with them? Have they answered all your questions? Are you satisfied with all the work that they have done for you? Sir, I've got two identical plea forms here entitled Plea of Guilty or No Contest to Criminal Charges in Circuit Court. Each one has your name on the top, your initials on the left-hand side, front and back, and your signature on the back. Did you go over both of these forms? Any questions about what's on either of these forms?
With credit of more than 700 days of time served, Cortlen Henry is likely looking at getting out of prison in 8 years.
Mr. Henry, I'm not quite sure how your lawyers managed to do this, but I wish you good luck, sir.
So some well wishes there from Judge Fine to Cortlen Henry, but let's talk about this plea agreement with criminal defense attorney Safa Robinson Ferrer. Safa, always great to see you, and thank you so much for joining me. Now, with this proffer that Cortlen Henry has to do, the deal is already set in stone. So in my mind, he doesn't necessarily have to cooperate with prosecutors or even testify against YNW Melly. But what are your thoughts? Do you think that he'll end up being very forthcoming with information during this proffer?
Going to be interesting to see what route he takes. And of course, with a proffer, it's an offer of proof, an offer of information or evidence and things of that nature that will ultimately come into play with a prosecution, assumingly YNW Melly's prosecution in this case. And so as far as I'm understanding it to be is that through this proffer agreement, of course, the prosecution wants him to cooperate, but there's no negative sanction for him if he does not. There's not a positive that he will receive if he provides certain information, and there's not a negative that he would receive if he doesn't cooperate or if he doesn't give any additional information. I think considering the possible lifestyle that he lives, and of course we're in a no snitching environment with certain demographics, that he probably will not say much of anything at all.
Yeah, I wouldn't be too surprised if he doesn't say much of anything either. I mean, I feel like part of me thinks that maybe he got the approval possibly from his alleged co-conspirator, that maybe it was okay to kind of go through with this, because if you're staring down a life sentence versus, 10 years in prison, I can understand why 10 years might sound a little bit better. And part of this sweetheart deal in a way, do you think it's a sweetheart deal? I mean, he was facing multiple life sentences, and now with credit of time served, he could just get out in 8 years.
Yep, it's a total sweetheart deal. He was looking at multiple life sentences on the back end and essentially spending the rest of his life in prison. With this plea agreement, the plea, he pled no contest, I believe, to 2 counts, and the sentence promises 10 years. We know he's been in custody for approximately 7, so he's really probably only got about a year to a year and a half left to do on his sentence before he's released. He's also going to be on probation or parole supervision for the next 6 years once he is released. So he will have to comply with the terms and conditions of probation or parole once he is placed on that. And so this is a total sweetheart deal. He walks out of here without actually admitting to anything. So yes, he's pleading guilty essentially, but not contesting or factually admitting to any of the facts as the prosecution would lay out, and receiving a sentence that would essentially have him home in about a year to a year and a half.
And so do you think it's kind of a rush to judgment from fans of the kind of YNW collective who are calling Cortlen Henry a rat and a snitch already in the Instagram comments, for example, when really he hasn't admitted necessarily to anything? He hasn't signed or written down, hey, this happened at this spot, we did this at this, like he hasn't done that to this point yet. It seems like it really is kind of open-ended as far as how much he's willing to give, if he is willing to give anything to prosecutors.
It's certainly a jump to conclusion, but I understand why people may think that. What often happens is prior to any plea negotiation or during plea negotiations and prior to any plea being entered by a defendant, there are many conversations that are going on, whether it be between the judge, the prosecution, and the defendant, or there's a bunch of conversations with would be myself or the defense attorney, the client, and other witnesses. And I would feel comfortable in saying there's a high likelihood that Melly and Mr. Bortlen ultimately probably had a conversation before he entered into this plea to say, hey, you're pleading no contest. There's nothing that you can say that will essentially hurt me. We're bros. We've been in this for quite some time. And that happens a lot. There are conversations between co-defendants, particularly people who are friends and people who have engaged or alleged to have engaged in certain conduct together. That's like, you're not going to snitch on me. I'm not going to snitch on you. At the end of the day, if that were to be the case, there's mutually assured destruction. And so how these plea negotiations often come about is with the attorneys having the conversation with the client and saying, hey, this is what this means. You walk out of here within about a year to a year and a half. There's no requirement for you to actually testify against Mr. Melly. If you want to, of course, that's your choice. If you choose not to, then you're not going to be negatively impacted by that. You're still walking out of here with a 10-year sentence that will ultimately be converted down in 6 years of supervision afterward.
And I wouldn't be surprised that the two possibly may have had a conversation in some way or form, especially given that I saw Melly's mom and even his brother inside the courtroom when that plea hearing was going on. And do you think it's at all possible that prosecutors are working on another deal for Melly too? I mean, his trial was pushed to 2027. He's been behind bars since 2019 with no conviction. But what do you think this deal with Cortlen Henry means for YNW Melly?
Well, I certainly think that it's probably in the prosecution's best interest to try to formulate a deal with Mr. Melly. At the end of the day, this isn't a slam dunk case for them. And we saw that in the first trial when it ended up in a mistrial and the jury ultimately couldn't come to a decision. And so considering that and the prosecution knowing that with the proof that they presented then, the proof is not really going to change substantially between that prior trial and his next trial. So they have to take that into consideration. And considering those things, they don't have the easiest case. It's probably more imperative for them to extend some sort of plea deal. Not only that, but, and I'm super interested in this, is now we're getting into speedy trial waters. Melly has been sitting in jail for quite some time, for years at this point on these charges. Within the United States and our constitutional framework, a person has the right to a speedy trial. So at what point does the rubber meet the road and the judge say, hey, if this case isn't brought to trial by this date at this time, then I'm going to entertain a speedy trial motion to dismiss on behalf of the defense, because this has gone on far too long and it's exceeded any constitutional framework that would have ensured Mr. Melly receives that fair and quick trial.
Right, exactly. And I know it's still kind of held up because of they're waiting on an appeals decision, all of that. But from 2019 of incarceration to 2027, that is a long period of time. I don't think I've ever seen a case kind of just sit in the purgatory of the legal system, just kind of waiting. Even though we did have that first trial, I kind of thought the second trial would happen a lot sooner than it has been. And I know a lot of the focus when I'm talking about this story or we're talking about this case is always either YNW Melly or Cortlen Henry, but the two are accused of killing their friends and covering it up to look like a drive-by. What do you think this message and this plea deal sends to the families of Anthony Williams and Christopher Thomas Jr., especially as they've probably been waiting for some form of justice for so long now at this point?
They're probably not happy about it. But one of the things that families have to understand, and I would always have this conversation as a former prosecutor, is ultimately at the end of the day, I represent the state. The prosecution represents the state of Florida. While they are advocating on behalf of these victims, their duty is to the state and to protect the individuals and citizens of the state of Florida. And so while they can take the family's wishes into consideration, and they will probably strive to do that as best as possible, the prosecution may sometimes have to make decisions that go against what a family of a victim would like in order to at least salvage some of the prosecution and kind of, get some sort of accountability and time out of a defendant.
And I just, I'm always thinking about their families, especially because, they lost their 2 young sons at such a young age. They wanted to be just as great in the world as probably YNW Melly wanted to be. Cortlen Henry rising up into the music industry, and then that shooting happened back in 2018. Again, Safa Robinson-Ferrer, I want to thank you so much for your time and your insight into this case. I really appreciate it.
Thanks for having me.
It's unclear where Cortlen Henry will be serving his prison sentence. As of this recording, online records show he's still in the Broward County Jail. Thanks so much for joining us here on Law and Crime. I'm Elizabeth Millner.